I've got Setu Kamal here today, and I would like to ask him a few questions about tax law. Setu, could you explain to me what is meant by POTAS?
Yeah, that's actually a very topical question, Kadan. POTAS actually represents a shift in the last few years in HMRC practice, moving away from looking at the substantive provisions of tax law and looking more and more at the way in which tax schemes are actually implemented. POTAS was actually introduced by the Finance Act 2014, and in essence, what it does is when you have a promoter who actually implements tax avoidance schemes, and he is in breach of one of various thresholds within the Finance Act 2014, then HMRC can come along and actually impose a conduct notice or a monitoring notice, and in effect, these inhibit the activities of the promoter. By the way, just one thing I would highlight is what I find interesting from a policy point of view, or from a philosophical point of view even, is the notion that if something is right to do as a matter of practice and as a matter of law, then the objection that HMRC take to the mass marketing of that idea or the industrialization of that idea, I find it hard to stomach, but that is really the way in which things are going.
That's really interesting. So what is a promoter?
Promoter is someone who actually, in very simple language, is someone who is responsible for the implementation of tax avoidance arrangements. There are three conditions which have to be met under the rules in the Finance Act. One is that the promoter has to be someone who is responsible for the design of the arrangements. And one of the interesting questions which arises here is what is meant by being responsible for the design? Does it mean that you have to be creatively responsible, or do you have to be legally responsible for the design? And the view I take is that you only fall within this limb when you are legally responsible. Then, in addition to that, you are a promoter if you make the arrangement available for implementation by another person. And whether you are in a position to be able to do so, or whether you have the authority to do so, is something which will be very fact-specific.
So would introducer be caught?
That's actually an interesting question, and I'm glad you asked it. In my opinion, an introducer wouldn't be caught within these provisions, quite simply because he is not someone who is responsible for the design of the arrangement, whether it be creatively or should it be legally. In addition to that, he isn't someone who actually makes the arrangement available for implementation. An introducer, as a matter of law, probably wouldn't have the intellectual property, he wouldn't have the know-how, and it wouldn't be within the scope of his duty to make this arrangement available. So the answer is, in my opinion, not.
Okay, thank you very much. There have been some changes from the Financial Act this year. What are the highlights?
Well, as I said, POTAS was introduced last year, and what HMRC or the Treasury may have felt is that there were certain lacunae in place with respect to the original enactment. And in particular, if you were a promoter and you breached the threshold condition, then there wouldn't have been any objection to you then starting up afresh through the use of a company as your alter ego. And so what the Finance Act 2015 tries to do is really to prohibit such activity. Whether this is something which is correct as a matter of natural justice is questionable. There's no reason why, if you have breached the threshold in the past, you shouldn't be allowed to make a fresh start through a new company, but this is not the view which is taken by the extensions under POTAS 2015.
Okay, so what steps can be taken to fall outside the regime?
Well, there are a number of things which can be done. First of all, it's best not to be a promoter where that is at all possible. The next best thing is not to breach one of the threshold conditions. And the problem here is that there are a range of threshold conditions. On the one hand, you have a slightly more egregious looking condition. So if you have activity in the past, or if you have breached one of your professional regulations, then you are actually in violation of the threshold condition. But as you move down the spectrum, then you get to a stage where actually, if you've done something as relatively innocuous as advice on a tax avoidance scheme, which should have been disclosed under DOTAS, but which you haven't, even though you sought legal advice, or if you actually helped implement a tax avoidance arrangement, which, in the opinion of the GAR panel, is required to be counteracted under GAR, then the situation is that you will nonetheless have breached one of these conditions. So even though it's very easy, in short, for me to say, well, don't breach one of the threshold conditions, it's not quite clear whether that will be easily achieved in practice. Setting aside all of this, of course, there are systematic or structural changes which can be introduced to your business with a view of protecting you with respect to POTAS as well. But that's something which is going to have to be looked at more minutely in practice.
I would like to ask you about the changes to the DOTAS regime.
Well, the DOTAS changes are very topical. What we find is there are, well, just to explain, by the way, for people who are new to this particular area, DOTAS was introduced in 2004, and what it does is it imposes an obligation on people who disclose tax avoidance arrangements to disclose them on to the government. And in order for you to have such an obligation, your arrangement has to fall within the prescribed descriptions, regulations, and within these regulations, you have certain hallmarks, and when these hallmarks are met, then you make a disclosure. What the new changes are doing, they are changing the hallmarks. And in the context of income tax, the position is that there used to be a grandfathering regime. So if your arrangement was something which HMRC knew of, then that was not something which you had to disclose. The exception came about, it was an exception to Regulation 10. So there's Regulation 10, which gives positive descriptions, which you have to fall within. And then there is grandfathering under Regulation 11. And that is what they are removing. Yes, that really is the change coming about with respect to the general changes to hallmarks.
Okay, thank you very much. What about the changes to the IHT, the hallmarks?
The IHT hallmark changes are being changed significantly. So the change being introduced here is that previously there was only a liability, or you only fell within the prescribed descriptions when you had an arrangement to settle property, essentially, which would then become relevant property without there being an IHT charge. The new regulations are actually drafted extremely widely, and so the position quite simply is that if you have an arrangement where one of the main purposes is to mitigate or avoid liability to IHT, then there will be, you will be falling within that hallmark. In respect to this change, I'd like to make one or two observations. First, that the position now is that the provision in the Mother section, or the Mother Act, Finance Act 2004, is actually more narrow than the regulation itself. So it may be that you fall within the regulation, but then you fall out of it by not falling within the definition of notifiable proposal or notifiable arrangement in the Finance Act 2004. But also certain other slightly more philosophical questions arise. When can it be said that a benefit has arisen to a person by reason of an inheritance tax scheme? Because, of course, this is a tax which is levied after our deaths, and if there is a benefit at all, it often is to the heirs. But, of course, inheritance tax isn't really a tax on heirs, it's a tax on giving and on the loss to a state. So there are questions arising whether very many inheritance tax schemes would fall within this definition for that reason.
What should promoters do going forward?
Well, that's an interesting question. Just by way of policy, one thing I would like to highlight is that how precarious the position is. There was the case of Meju, which came out last year, and just by way of explication, Meju actually involved an Iranian domiciled individual who set up a company in the UK and he sold it for 22 million. And when it came to sell, he sought advice from his accountant who suggested that he secure entrepreneur's relief. And therefore, he ended up paying £800,000 by way of CJT. Down the line, it became apparent that actually he was non-domiciled and he could have sought reliance on the bearer warrant scheme, and he therefore sued his accountants for not having suggested this route to him. And in the High Court, the judges took the view that actually the accountants would have had an obligation to put forward this arrangement to him. Of course, since then, there has been the Court of Appeal decision, which came out last year, and what the judges there have said is that there is no obligation in this case because his accountant was an everyday accountant. He was like a run-of-the-mill accountant. And therefore, there wouldn't have been any obligation on that particular advisor to put forward the bearer warrant scheme or indeed the best possible arrangement. However, that's the case of that particular accountant. For those of us who are specialist tax advisors, what follows from Meju might be that actually there is an obligation on us to provide the best possible arrangement out there. 2 points to make here. First is that, well, actually, the tax planning world is very different to what it used to be 5 years ago, when you had a more static world and people knew what is the best tax arrangement in a given situation. Now things are less clear. But the other thing which I find problematic is that there's a conflict, because on the one hand, there's a duty on the advisor to give the best possible tax avoidance arrangement, and on the other hand, where he does so, then there's a danger that he might be exposing himself to liabilities under DOTAS and POTAS. And so the question is, what is he meant to do? Going forward, what I would recommend is that a promoter actually seeks tax advice, especially with respect to DOTAS. Prior to 2015, the position was that you either, disclosing under DOTAS was something you did in your own interest. Going forward, if you do make a disclosure, then there is a possibility that you might be bringing your client within the APN regime, because of course DOTAS is one of the gateways into the APN regime, and therefore you have a conflict of interest. The only solution to that is to go to someone who specializes in this, or to go to counsel and get advice to the effect that you are not falling within DOTAS, and likewise and that would also assess with respect to the POTAS thresholds as well.
Okay, thank you very much. That was all my questions.